Good evening. Welcome, everyone. We're so excited to have you joining us for Constitution Day 2024 here at Stockton. My name is Claire Abernathy, and I'm an associate professor of political science here at Stockton and the co-chair of the Constitution Day Planning Committee. Since 2006, Stockton has commemorated Constitution Day each fall with a keynote address. Every year, we're able to learn from prominent legal scholars, practitioners, or journalists as they discuss the most pressing constitutional issues of the day. We are so proud of this Constitution Day legacy at Stockton, and we are happy for all of you to be in this room with us as you exercise your civic commitment to learn more about our democracy and the constitutional foundations that inform it. This annual event requires a great deal of work from a very dedicated team. It is my great privilege to work alongside co-chairs Dr. Lauren Belasco, Associate Professor of Political Science, and Dr. Tina Zappilli, Faculty Director of the Hughes Center for Public Policy, as well as our Constitution Day Planning Committee to make this event happen. We want to thank the Hughes Center for Public Policy, Event Services, Production Services, University Relations and Marketing, University Advancement, as well as the faculty membership of the Planning Committee for your excellent work in supporting Constitution Day 2024. This year, we are also pleased to have 3 Constitution Day Fellows supporting the event. Thank you to Deti Exantus, Lindsay Grande, and Ashley Ramirez for your valuable contributions this year. As we begin our keynote this evening, I'd like to share a couple of brief announcements. At the conclusion of Professor Hassan's address, we will have about 15 to 20 minutes available for audience Q&A. On your seat, you will find, importantly, a pocket constitution, which we hope you all take with you, as well as a note card and a small pencil. Please write any questions that you have, even during the speech tonight, down. And once Q&A begins, we will have student volunteers that are circulating. Our Constitution Day Fellows will be coming around to collect your note cards. Sarah Farrow, Director of Alumni Relations, will then pose your questions to Professor Hassan up here on stage. We do ask that you stay for the duration of the event, both the keynote address as well as the Q&A to follow, and we expect to conclude around 7:30. I'll also share that we have copies of Professor Hassan's book for sale, and those interested in purchasing a copy can do so in the Board of Trustees room immediately down the hall following the event. Finally, as Professor Hassan will explore with us in his keynote, the right to vote is one of our most fundamental rights in a democratic society, yet in the United States, this right is not guaranteed. Tonight, as we reflect on Professor Hassan's recommendations to ensure a real right to vote, please be sure you are registered to vote and be ready to be a voter this fall. We have voter registration available directly outside the event room. Some of you might have passed it on your way in. We encourage you to stop by on your way out and check your registration status and register to vote if you haven't done so already. It is now my honor to turn things over to President Joe Bertolino, who will be introducing our keynote speaker. We are grateful that our leaders in higher education, like President Joe, support events such as Constitution Day to help us promote civic engagement and foster deliberative dialogue on the most pressing political issues of our time. Please join me in welcoming President Joe Bertolino to the stage.
Thank you, Professor Abernathy. I really appreciate it. Welcome to Stockton, everyone. How many of you are our current students? Raise your hand. Look at all of you. Thank you for being here tonight. And how many of you are alums of Stockton? Wonderful. So the legacy continues. We're very excited to be with you this evening. Good evening to all of you. Well, as you heard, my name is Joe Bertolino. I have the privilege of serving as the president of the university. And most people here know me as President Joe. So I am delighted to welcome you to Stockton University's 19th annual Constitution Day keynote. This evening underscores Stockton's commitment to developing engaged and effective citizens. You heard earlier the importance of registering to vote. Not only do we encourage you to register, if you haven't already done so, but once you do, please make sure you exercise your right as a registered voter. It is extraordinarily important, not just for our nation, but for each of us as individuals, as we engage you to be good citizens, and as we do our very best to ensure that we are taking care of each other, our community, and the people around us. As an institution of higher education, it's our responsibility to provide the setting for democratic participation, to offer opportunities for our students and our community to converse with those with differing viewpoints and life experiences. The Stockton community is one that values inclusivity, providing an environment where all voices can be heard. The strength of our democracy relies on all of us to be educated on the issues that affect our community and beyond. Sometimes, the act of learning and understanding these issues can feel very uncomfortable, can seem difficult. I have talked a lot about being uncomfortable in our community. There is a lot happening in the world, and as a result of that, we may sometimes feel uncomfortable. But it is in that very space, that uncomfortableness, where we learn about ourselves, where we learn about others, and where true engagement and true education can occur. So my challenge to you tonight, and as you move forward, particularly to our Stockton students, don't be afraid to be uncomfortable. Being uncomfortable provides amazing opportunities to share your life story and your perspectives and to learn about others and their experiences. Yes, it can be difficult, but it is vitally important to advancing our community and our nation toward a more equitable and inclusive future. Tonight's keynote event comes at a very important and opportune time. This year's presidential campaigns have been unique, often divisive, and with raised tensions. Events such as Constitution Day provide an opportunity to listen, to learn, and to engage. Richard Hasson is the Gary T. Schwartz Endowed Chair in Law, Professor of Political Science, and Director of the Safeguarding Democracy Project at the UCLA School of Law. As an aside, I will share with you that Professor Hasson shared that in comparison to some spaces at UCLA, Stockton is a beautiful place to be. So you're welcome to come here anytime you'd like. An internationally recognized expert in election law, Hasson writes the Election Law blog, which tracks current developments in voting rights and access around the country. He is co-author of leading casebooks in election law and remedies, and has written more than 100 articles on election law issues, published in many journals, including the Harvard Law Review and Supreme Court Review. Professor Hasson has served as an analyst for CNN and NBC News, MSNBC, and his op-eds and commentaries have appeared in the New York Times, the Wall Street Journal, the Washington Post, and Politico. Tonight's address, titled A Real Right to Vote, will examine the U.S. Constitution, its lack of an affirmative right to vote, and how this absence of affirmative affirmation leaves American democracy vulnerable and negatively impacts every citizen. I'd like to thank you all for coming this evening to bolster your education on the issues that impact our nation. I'd also like to thank, as you heard earlier, the Constitution Day Committee, including our co-chairs, Professor Claire Abernathy, Professor Laura Belasco, and Professor Tina Zappilli, for planning this important event. And thank you to the sponsors of this evening's event, the William J. Hughes Center for Public Policy, the American Democracy Project at Stockton, the Stockton University Foundation, and the Office of Development and Alumni Relations, and the Office of the Provost. Thank you, Rick, for joining us today to share your important topic and more issues and its impact on our elections. It is with great pleasure that I introduce Rick Hasen. Rick, thank you very much for being here. Appreciate you.
Good evening. Great to be with you. I want to thank President Joe and the Provost and Claire and Lauren and Tina, the committee, and everybody that put this together. Very warm welcome, and I had a great afternoon speaking to some fantastic political science students. You all got a copy of the Constitution at your seats, and I'm not somebody who gives my students pop quizzes, but if I were, I would ask you to look in this document and find where the right to vote in the Constitution is. And you will find that it is not there, as I will explain. In fact, I noticed it's not just the Constitution, there's an index in the back. And if you turn to the index and look up voting rights, you see it just talks about things you can't do about voting, not things you can do. So I will get to that. But I thought I'd start in talking about a real right to vote by telling you the story of two people who both went to the Supreme Court to argue for their voting rights. The first is Virginia Minor. She was a woman, was a citizen of the United States, a resident of Missouri. She lived in Missouri, and in 1872, she wanted to be able to vote for president. And she went to the polling place and was told that she is not allowed to register to vote because she's a woman, and the Missouri Constitution said that only men were allowed to vote. So she filed a lawsuit. She went to the United States Supreme Court, and she said, we just fought a civil war. We passed the Reconstruction Amendments, the 13th Amendment that abolishes slavery, the 14th Amendment that guarantees equal protection and due process and guarantees citizens the privileges or immunities of citizenship, the 15th Amendment that bars discrimination and voting on the basis of race. I should be allowed to vote because I'm a citizen, and voting is a privilege of citizenship. And the Supreme Court, all men, said, yes, you are a citizen, but voting is not a privilege. Voting is not a right. Voting is something that states decide whether you have or not. And Missouri decided that you do not have the right to vote. It was not until 1920, as I'll talk about, that a constitutional amendment was passed that said not everyone has a right to vote, whether they're a man or a woman, but if you're going to hold an election, don't discriminate on the basis of sex. So it didn't guarantee the right to vote to anybody. You can look through the Constitution. There's no part of the Constitution, the original part before the amendments, that guarantees anyone the right to vote. Vote for president? No, it says state legislatures shall direct the appointment of electors. Vote for senators? It said the same thing. In fact, we didn't get to vote for senators until the 17th Amendment passed. That didn't come, for more than a century later. For the House of Representatives, it did guarantee an election, but who was allowed to vote in that election? Whoever state said were qualified to vote in that election. Maybe you had to own property, be able to read English, maybe you had to be white. Whatever the state's rules were, that's what applied. And so when Virginia Minor went to the Supreme Court and asked for the right to vote, not only was she told she doesn't have the right to vote, but the court said, really, no one has the right to vote. That right is coming from the states. As bad as that story is, and I think it's a pretty terrible story, although it has a happier ending, as we'll talk about with the 19th Amendment, the story of Jackson Giles is much worse. Jackson Giles was an American citizen. He was a resident of Alabama. He was an African American. He went to register to vote, and Alabama had a policy that they would not register black voters. They just couldn't register at all. So he went to the Supreme Court, and he said, I'm a citizen. I've read the Constitution. I read the 15th Amendment. You can turn and read it yourself later if you want. It says the right to vote shall not be abridged on the basis of race. This is race discrimination. I should be allowed to vote. And the Supreme Court, all white men, said, yes, you're a citizen, and yes, the Constitution says no discrimination on the basis of race, but what can we do about it? We're just the Supreme Court. It's really up to Alabama to enforce the Constitution. And so in 1903, the Supreme Court said, we're not going to do anything to assure that African Americans actually can vote. And when did the voting rights really come in the American South for African American voters? Not until the passage of the Voting Rights Act in 1965. And that was not the Supreme Court. That was, in fact, the Congress. And there's been a little bit of a battle between Congress and the courts over voting rights, as we'll see. So what I'm going to do today is three things. First, I'm going to give you three reasons why I think we need to amend our Constitution to affirmatively have a right to vote in it. Second, I'm going to talk about what would be in a constitutional right to vote. And actually, in the back of my book, I tried to draft one. And it looks very different than some of the current amendments for reasons I'll explain. And then the third thing, which is often the first question I ask, is how is this going to happen? Congress can't even fund itself for the next 3 months. How are we going to get, you know what it takes to get a constitutional amendment? 2/3 of each house of Congress and 3/4 of state legislatures. So how is this going to happen? So I want to talk about that, and I want everyone to shift their time horizons. And I'll tell you what happened, how we got the 19th Amendment, and I think it would be a good lesson for us today. But the question is, why don't we have in our Constitution a part that says every citizen, adult, resident has the right to vote? Like it's in the German Constitution, it's in the Canadian Constitution. Most modern democracies around the world say this. And a part of the reason is historical, which is that at the time that the Constitution was written, we're talking about 1789, there was no belief in universal voting rights. Property ownership, literacy tests, these were all very common things. And our Constitution has been amended, but it hasn't been fundamentally rewritten. So newer constitutions, in fact, do guarantee this right, but we do not see that. So in talking about why we need to have a right to vote, I need to back up first and talk about the role of the Supreme Court in history. Because I think that people I talk to who are not constitutional scholars are kind of shocked that there's no right to vote in the Constitution. And part of the reason for that is because there was an 8-year period in the mid to late 1960s when the Supreme Court became very protective of voting rights. And those rules that the Supreme Court put in place during that time apply somewhat today as well. But as I'll talk about, those precedents that the court created are in some danger. And in fact, if you look at the 235-year history of the Supreme Court, what you'll see is that there were 8 good years and more than 220 bad years. And we cannot count on the Supreme Court to protect our voting rights. So let me tell you about some of these cases from the 1960s. So there was a man named Herbert Carrington. He was a sergeant in the United States Army. He lived in Alabama, and he got stationed in White Sands, New Mexico. So he moved his family to El Paso, Texas, which is not that far from White Sands, set up a little side business, enrolled his kids in school. His wife was working. He was very much a part of the community. And he went to vote in the Republican primary and was told that he could not register to vote in the state of Texas. This is in 1960. Why couldn't he vote? The Texas Constitution said if you're a member of the military, you are not allowed to vote in the state of Texas. All right, it's kind of shocking, right? Not allowed unless you were already a resident before you joined the military. And Carrington was upset about this. He went to the Texas Supreme Court and he lost there. And he went all the way to the US Supreme Court and he said, I have the right to vote. And he didn't rely on the privileges or immunities of citizenship, the part that Virginia Minor did in the Minor versus Happersett case, because the Supreme Court had essentially read that part of the Constitution as though it has no application to anything today. That's a different lecture. He said, this violates my right to equal protection, which is also in the 14th Amendment. And Texas said, we have two reasons why we want to disenfranchise Sergeant Carrington. Number one, these people in the military, they're not really residents. And everybody agrees you can limit voting to residents. So I live in California, I can't vote in the New Jersey governor's race, right? We limit to residents. And he's not really a resident because these people are just passing through. And the Supreme Court said, well, as a matter of fact, that's not true. He's living there, he's established in the community, just like if he had a job in the private sector. So there are some military people who are just passing through, but many make their lives there. But then Texas made a different argument, and it's the one that's much more interesting and I think much more pernicious. Texas said, look, if we let people in the military vote, they're going to swamp the votes of the people that are already living there, and that might change the outcome of elections. And the Supreme Court's response was essentially, yeah, that's a feature, not a bug of democracy. If you allow people to vote, you might get different outcomes. You cannot fence people out, the Supreme Court said, because of how they might vote. But that, as recently as 1962, this is what Texas was arguing. And I think it underlies a lot of what we see today, trying to shape the electorate by creating voting rules to make it harder or easier for people to vote in order to try to affect election outcomes. Okay, the other case I'm going to tell you about from the same period of the Warren Court in the 1960s involved a man named Morris Kramer. In my class, we call him the bachelor stockbroker. He was a 31-year-old bachelor stockbroker living with his parents in upstate New York, and he wanted to vote in a school board election. And the rule in New York, so don't think it's just Texas that's disenfranchising, this is New York in 1964. The rule in New York was you can't vote in school board elections unless you are the parent of a child, of a school-age child, or you own or rent property. And he didn't own or rent property because he was living for free with his parents. And this also applied to, for example, people who were ministers living on property owned by a church. They don't pay rent, right? So there were lots of people who this would apply to the homeless, right? So it would disenfranchise a lot of people. And the Supreme Court said, also applying the Equal Protection Clause of the 14th Amendment, that voting is a fundamental right, right? We heard Claire say that earlier. Voting is a fundamental right. It is something that protects all adult citizen residents. Okay, so the Supreme Court said that, and in the same time period, they also said, we're going to have a one-person, one-vote rule, which I'll talk about a little later, that people's votes are going to be entitled to equal weight. All of these precedents were based not on a historical originalist reading of the Constitution, but based on what we might today call living constitutionalism, a theory that the Constitution should evolve over time. Now, that's a great theory, and I actually think it's a just fine way to read the Constitution, but there are 6 justices on the Supreme Court that utterly reject that way of reading the Constitution. And so if our voting rights depend upon these cases being upheld by the Supreme Court, we're in some big trouble, because I don't think they would do it unless they're willing to respect precedent. And if you look at some of the other cases that the Supreme Court's decided in a few years, they're not always willing to respect precedent. So our voting rights depend primarily on the Supreme Court continuing to go down a particular path, and on states being nice enough to us. And what that tells us is where we live tells us a big part about how protected our voting rights are going to be. So for many people, probably for over 90% of people in the United States today, voting is easy and it's simple and it's just, I know I get a ballot in the mail, I fill it out, I go a half a mile to my library, I put my ballot in a drop box, I get a text that it's been scanned and my vote's been counted, easy peasy. But that's not true for everybody. And because states have the ability to decide what their voting rules are going to be, consistent with some basic floor that the federal government puts in through these constitutional cases, voting rights differ from place to place. So last night I was giving this lecture in Indiana, and I talked about, in Indiana, I list some cases at the bottom of the slide, There's a case called Crawford versus Marion County Election Board. In Indiana, it was one of the first states that said, if you want to be able to vote, you have to show photographic identification, like a passport or a driver's license. And there were only a list of like 5 things you could show. And for most people who drive, not a big deal. What if you're not a driver? What if you're poor? What if you have trouble getting the ID? Okay, we'll make the IDs free for you, but we're not going to make free for you the birth certificate or other proof that you need to get it. So some voters went to the Supreme Court and they said, this is violating our voting rights because this is a burden on our rights. And one of the justices at the oral argument asked Indiana's Solicitor General, the person arguing the case, how much evidence do you have of someone impersonating someone else, going to the polling place, pretending to be someone else, and voting in that way? Because that's what a voter ID law would stop, right? You pretend that you're your neighbor and show up and vote for them because you know their name and maybe you know their address. And the answer was 0. There had never been a case documented in the history of the state of Indiana of anyone trying to commit fraud this way, because it's a very stupid way to steal an election. If you want, after the talk, I can tell you easier ways to steal the election. This is not one of them, and it really does not happen in the United States. So the Supreme Court said, well, that doesn't matter. Because this law is not a burden for most people, it's constitutional. And if there's some group of people who have a problem, they can come back and file their own lawsuit. I mean, these are people, probably some of the poorest people in society. They're going to have to find lawyers and file their lawsuit. Here's what Indiana says. If you are so poor that you can't afford the birth certificate to get your free ID, you can vote, a provisional ballot, you vote at the polling place, and then you have to go at your own expense to the county seat and file a piece of paper swearing that you're too poor to have this. And you have to do this in every election. You can't do it once. Even in Texas, they let you do it once. And they let you do it at the polling place. But here you have to take a trip. Could be 20 miles, could be 50 miles, at your own expense. Same thing if you have a religious objection to being photographed, and there are some people that do. You want an exemption? Every time you vote. Why put these burdens in front of voters? Right? So the idea of the reality of voting is we have kind of a dual society. For many people, voting is very, very easy. And people have even a hard time understanding what's the fuss about. But for some people, it can be much harder. And if we are going to be a society of political equals, and this is my main argument for why we need a constitutional right to vote, if we're going to be a society of equals, we should be a society where it doesn't matter if you can read or write in English, it doesn't matter how you're going to vote or how rich or poor you are, we're equals, we all should have the right to vote. So long as we are eligible to vote, we all should have the right to vote. And one of the stories I tell, because Texas is not done making it hard for people to vote, is the story of Prairie View A&M University, a historically black college in Texas. It's in Waller County, Texas. And back in the 1960s, the registrar of voters there would not let the college students register to vote in Waller County unless either they had parents who lived in Waller County or they had a spouse who lived and worked in Waller County. Otherwise, he said, you're not really residents. Kind of the same argument that was made in the Carrington case about the military voters. These voters had to go to the Supreme Court to get their voting rights, and they relied not on the Equal Protection Clause, they relied on the 26th Amendment. You know the 26th Amendment? That's the one that says no discrimination in voting between 18 and 21. Right? For decades since then, the registrars in Waller County have been making it hard for college students to vote. The most recent lawsuit, and the woman pictured on this slide, her grandfather, her father, her sister, they all had problems registering to vote, like going on for decades. That last lawsuit was Waller County decided we're going to set up some in-person early voting sites. And they put them all over Waller County, but not near the college campus. You know, what is that about? Here, I'll give you one more example from Texas. I'd like to say I could teach my entire election law class with just examples from Texas, or North Carolina for that matter. So during the pandemic, Texas is not a big believer in voting by mail. So during the pandemic, they had lots of in-person voting, but some people didn't feel comfortable voting in person. In Texas, if you want to vote absentee, if you want to vote by mail, you have to be out of the country, or like you're in the military, or you have to prove that you're sick, and if being afraid of getting COVID was found not to be enough. But if you're 65 years old, you can automatically get an absentee ballot. And some voters who are under 65 said, hey, you're violating the 26th Amendment. You're discriminating on the basis of age. You're saying over 65 gets this, and under 65 does not. And it didn't go all the way to the Supreme Court, but the Fifth Circuit, the United States Court of Appeals for the Fifth Circuit said, voting by mail, that's not a right. So Texas can just give it to some people. Now, I question if they would have given it just to men or just to white people, whether we would feel the same way, but just to old people, that was just okay. So we have a problem in this country, not everywhere, and it's not severe for everyone, but for enough people, we have a problem. Political equality is the reason, the primary reason to enshrine the right to vote in the Constitution. I'm now going to turn to two other reasons before I tell you what I think should be in the right to vote. So the first is I've been tracking election litigation, lawsuits over elections, since 1996. And here's what we know. The rate of election litigation has nearly tripled in the period since 2000, the disputed 2000 election that ended with Bush versus Gore. Election litigation has tripled. It hit a record in 2020. That was the COVID election. That was the Trump-Biden election. Hit a record. Why do we have so much litigation? Well, the 2000 election taught people that in very close elections, the rules of the game matter. So let's start changing the rules a little bit. Okay, we could change the rules a little bit. When you change the rules, what happens? People sue. That's the American way. This rule is discriminatory. This rule has a problem with it. And so it leads to the cycle of the parties trying to find political advantage by making minor changes in voting rules, leading to lots of litigation. And so in the chapter where I talk about this, I say that if we actually enacted a right to vote along the lines that I propose, you'd have a lot less litigation. And the example I give is litigation over voting rights in North Dakota for Native American voters. So in North Dakota, in around 2012, Heidi Heitkamp, she's a US Senator. She was elected from North Dakota. She was a Democrat, even though the state was trending red. She was elected, she won by 3,000 votes. She won with the help of Native American voters who voted heavily Democratic. The next year, the state legislature put forth a new rule. If you want to vote, you have to provide, with your name, a residential street address. What a weird rule, right? For all of us, like we all, can you tell me you live at 123 Elm Street? Like it's no burden at all. But it turns out that there are some poor Native American voters who live on reservations where they do not have dedicated street addresses. They would say, you know, I live off the mile marker 185 on this road. In some of these places, very far removed, you know, you tell people vote by mail or make a photocopy of your ID. There is no mailbox for 50 miles in some of these places. Why did the state pass this law? To make it harder for this small group of people to vote. So for most of us, not a big deal. For this group, very big deal. 8 years of litigation to resolve this, including the tribes having to create new tribal identifications and get them to people at the last minute. If we had a right to vote in the Constitution, a lot of this litigation would go away, and we would be siding with the voters. Again, if you've got a good reason why you need to put a rule in place, like you're worried about fraud, that's fine. But there was no evidence that the voters living in this area were committing any fraud. It was just about putting stumbling blocks in front of voters for political reasons. Okay, so first reason we need is political equality. Second reason we need it is to de-escalate the fighting between the political parties over voting rules. And the third is what we learned in 2020, the risk that our elections could be stolen, could be subverted. You may remember that the plot to try to steal the 2020 election, the fake electors, I'm sure you've heard this term, the fake electors, what was that? It was a theory that even after people had voted in certain states where Joe Biden had won, but that Republicans controlled the state legislature, the legislature could just swoop in and appoint a different slate of electors. It didn't happen. We got lucky. But let's back up and talk about this. You remember I told you that the original Constitution, Article 2, does not guarantee the people the right to vote for president. It says the people, it says the states, through their legislatures, can set the rules for presidential elections. In the 2000 case of Bush versus Gore, the case that ended the dispute over the 2000 election, the Supreme Court said, this is in 2000, this is not like back in 1872. In 2000, the Supreme Court said the Constitution does not give people the right to vote for president. But once states give it to the people, that right becomes fundamental and you can't discriminate one set of voters against another. And so the idea was, well, the legislatures can take it back. Now, I don't think that theory would have worked anyway, because they can't take it back after the election has already happened. But the whole idea that our Constitution does not give us the right to vote for president, again, look at the Constitution of Germany. It says every citizen, adult resident can vote for their parliament. Same thing in Canada. Why is our Constitution different? It would solve a lot of problems if our Constitution actually said this. So what would I put into a constitutional right to vote? And as I said a little bit earlier, my constitutional amendment looks a little different. Right? So if you look at, say, the 15th Amendment or the 19th Amendment, they're very short. It basically says, do not deny or abridge the right to vote on the basis of sex or on the basis of race. Congress shall have the power to enforce this by appropriate legislation. That's it. Mine goes on for 6 pages. Why? Because I don't trust the court, and you need to give them explicit directions and box them in. Okay, so these are the headlines. What would I say? The first is that all citizen, adult, resident, non-felons should be able to vote for every office where they are a resident, including for president. We should have equal weighting of votes. Let me talk about why this is important. So I tell my students in my election law class, say I have 20 students in the class, I say, all right, we're going to decide on the format of the final exam, if it's going to be open book or closed book. You can all vote. You each get a vote. You each get 1 vote. I get 25 votes. We could call that an election, but if I have 20 students and I have 25 votes, it's not much of an election. And before those cases in the 1960s, those one person, one vote cases, in California where I live, the smallest county, which had a few thousand people, and Los Angeles County, which had millions of people, they had the same representation in the state legislature. Same idea. The Supreme Court said you can't do that. But that's, again, part of the Constitution interpreted by these judges in the 1960s that I don't know is going to hold. The next thing I would do, and this would get rid of a lot of that election litigation, is I would say we should automatically register everyone who's eligible to vote. Every state should do this, and we should create a voter identification system, a national system, so that everyone would have a unique number that would follow them around. So if you live in New Jersey, and you move to California, your number would go with you. They'd know you're no longer a New Jersey voter, you're now a California voter. So it's got the kind of the voter access idea with the voter integrity idea. I like to say that this is an idea that unites Democrats and Republicans because they both hate it. Different parts of it they don't like. But if we're going to actually achieve something, we need to find some place for compromise. This is a kind of proposal that would bridge those things. The second thing I would say is we can't have overly burdensome voting opportunities. So for example, if a state's going to impose a requirement like you have to provide your residential street address, rather than the way the court does it today, which is to say the state doesn't have to come forward with actual evidence of fraud or some other basis, but the voters have to show a big burden, I'd flip that and say if the state is going to put a stumbling block in front of voters, it should have a good reason to do that. And I go into some detail about how that should work. The fifth thing I would do is I would take a key part of the Voting Rights Act, it's Section 2 of the Voting Rights Act. It's the part that says that minority voters should have the same opportunity as other voters to participate in the political process and to elect representatives of their choice. I would put that in the Constitution. Why? Again, because, first of all, we have a long history of discrimination, and if you look at where there are problems with voting, it is often a form of racial discrimination. And the Supreme Court has been interpreting this part of the Voting Rights Act in narrower and narrower ways, not adequately protecting voting rights. And the final thing I would do in my proposed amendment is that I would make it clear that Congress has broad powers to expand voting rights. If you look at all the voting rights amendments in the Constitution, the 14th, the 15th, the 19th, the 23rd, which gives the Washington, D.C., 3 electoral votes so they can vote for president, the 24th Amendment stopping poll taxes, and the 26th Amendment on age, they all end the same way. Congress shall have the power to enforce this amendment by appropriate legislation. And Justice Ginsburg, in a famous case called Shelby County versus Holder, in a dissent said, we should read all these together to say Congress has a vast reservoir of power to protect voters. She was in the dissent. That was not the position of the Supreme Court. It should be. And so I would put that in the Constitution. Okay, so this is what I would call the kind of the basic 6 requirements that we would need if we actually put the right to vote in the US Constitution. Now, we can get more complex. And in the next chapter of my book, I talk about 4 possible extensions of this right to vote. One having to do with people who've completed their felony sentences. Now, in the last 20 years, 16 states have made it easier for those who've completed their felony sentences to be able to vote. In most places, it has become easier. And my normal inclination would be, well, we can leave this alone because the political process will eventually get to the point that this will be how the law will be everywhere. But the experience that we recently saw in Florida convinces me that we might need to change the rules. And so here's what happened in Florida. Florida voters passed an initiative. It was supported by, I think, 67% of Florida voters, supported by a majority of Democrats, majority of Republicans, and majority of independents, that said that when you've completed your sentence, if you had a felony conviction, your voting rights would be restored. And there are well over 1 million former felons in Florida who could potentially get their voting rights back. Well, the Florida legislature didn't like this law very much. They're Republicans. They were worried that more Democrats were going to register. Not clear that that would actually be the case, but that's what the worry was. So they passed a law saying, we're going to implement this amendment that the voters passed by saying you cannot register to vote, even if you've completed your sentence, if you have not paid all the fines and fees that you might owe to any court in Florida. And the Florida legislature created no mechanism by which you could know if you owed any fines or fees. So it's not like you could type in your Social Security number online and see what you owe and see if you can vote. And what happens if you vote and you owe a fine or fee? Well, now you've committed a new felony. You can go back to jail. 67,000 out of the over 1 million former felons have registered to vote in Florida. So that tells me that there's a problem. Okay, so maybe we want to add this in. And I say maybe, and the reason I'm saying maybe in these things is I think some of these create harder questions, and also if there's going to be a political coalition that's going to allow this to happen, to come together, then some of the proposals might be deal breakers. So I hide them off as separate things. Let me talk about the second one on this list. People living in United States territories. You know, if you live in Puerto Rico or you live in Guam, you can't vote for president. You live in the Virgin Islands, you can't vote for president. If you move to New Jersey and establish residency here, then you can vote for president. And then if you move back, you lose it. If you move from American Samoa to New Jersey, turns out you can't vote for president. Because people from American Samoa are not considered citizens. I didn't know this until I wrote this book. They're American nationals, and they're not given even the right to vote, even if they live in the mainland United States. We have to do something about our colonial past. We have to do something to deal with the fact that we have people who are living under American sovereignty who are not being treated equally. Now, it's a really complicated question. Some of the people living in these areas want independence. Some of these people want to leave the relationship as it is. I would have self-determination, but if they want their right to vote, we should put that in the Constitution. One way to do that for president is say, let them vote with the people of Washington, D.C. Let's count all those votes together. So we wouldn't have to add to the Electoral College or change any of that. Okay. The third and fourth are the most controversial and would probably be the deal breakers, at least based on my conversation last night in Indiana. There are two parts of the Constitution, find it in here, two parts of the Constitution that don't follow that one person, one vote rule. The first is the Electoral College. Right? We don't vote as people. We don't have a national popular vote for president. We instead vote by state. And each state gets the number of electors equal to their number of representatives, which is based on population, plus 2 senators. A lot of people want to get rid of the Electoral College because it does not comply with this one person, one vote rule. The Senate is much worse in terms of malapportionment, in terms of unequal voting power. So I live in California. Right? We've got millions and millions of people. And we have the same number of senators, 2, as people who live in Rhode Island or Hawaii or Wyoming. You know how many Wyomings you could fit in California? Not area-wise, but people-wise? If you talk about on the Electoral College, in Wyoming, one elector equals about 180,000 people. In California, one elector equals about 680,000 people. So totally malapportioned. Now, the unequal weight in the United States Senate is so built into the Constitution that if you go and you look in Article 5 of the Constitution, this is the one part of the Constitution that says you cannot amend it. You cannot amend the Constitution to get rid of the United States Senate to its equal voting power. So you'd probably have to pass 2 amendments. The First Amendment would get rid of that part of the Constitution that says you can't amend this part of the Constitution, and then pass an amendment. This could well be a deal breaker. Small states, swing states, red states, none of them are particularly interested in getting rid of the Electoral College or getting rid of the Senate. Right? So in the Senate, you could have a minority, especially with the filibuster rule, which is not in the Constitution. You could have a minority, you could have a majority of senators or even a minority of senators representing a large minority of people being able to block what the majority wants. So that is not in line with the idea of equal weighting of votes, but that is such a difficult problem, it's hard to see how we could find, why would states like Wyoming or Rhode Island give up their equal voting power in the Senate? Very hard to, and that's not a Democratic-Republican issue. There are small Democratic states too. It's very hard to see. So there are all kinds of crazy proposals out there. You know, Democrats, if they win, let's say they win the presidency and the Senate and the House, by a majority vote, they could make Puerto Rico and Washington, D.C. a state and give them senators. That may happen. I don't think it's likely, but it may happen. It was talked about last time. I just saw there was a law review article in the Yale Law Journal, a very prestigious law journal, suggesting that D.C. should be made a state. It actually should be made 127 states. Each should get 2 senators. And then you can change the Constitution and do whatever you want, right? So we can start playing those games. I'm trying to figure out how can we actually get this right to vote in the Constitution. So before I turn to the history of the right to vote amendment for the last part of my talk, I want to go back and talk about the 19th Amendment for a minute. You remember I told you that in 1874, Virginia Minor lost in Minor versus Happersett. The Supreme Court said, voting rights for women, that's up to the states. We've got nothing to do with it. Well, what happened? The women's rights movement focused on states, on state constitutions. It took 40 years, but by the time we got to 1920, when the Constitution was amended with the 19th Amendment, 30 states had amended their state constitutions in order to provide no discrimination in voting on the basis of sex. Along the way, that fight for voting rights paid dividends. So that's why I don't think, if I look ahead 5 years, are we going to have a right to vote in the Constitution? Absolutely not. And I'm not selling it that way. But if people organize in each of their states to fight for voting rights, and in our decentralized country, there's room to improve things about voting rights in every state, we could eventually create a movement around voting rights. That's this idea about paying dividends along the way. Now, there has been a history of trying to put a right to vote, an affirmative right to vote in the Constitution. In the late 1950s, early 1960s, this was proposed. And then it got dropped because what did we get? We got a number of constitutional amendments protecting voting rights. We got the Civil Rights Act in 1964 and the Voting Rights Act in 1965. So the proposal got dropped as kind of unnecessary. Then after the 2000 election, it came up again. People said, our election system is crazy. What does the Supreme Court mean when it said in Bush versus Gore, we don't have the right to vote for president? But it didn't really go anywhere. And there were a bunch of activists trying to get the Democratic Party, at least, to endorse this idea of putting a right to vote in the Constitution, and the Democratic Party would not do it. Why not? One theory is they thought, well, you know, those Warren Court precedents, they protect the right to vote pretty well, and if we start saying we need a right to vote, maybe the courts are going to read that we don't really have a right to vote already. So the politics were a little funny. But there have been these proposals, and after 2020, you know, I and others have come back to this idea that maybe we need to put in the Constitution. Almost everyone since 2000 who has proposed this has been on the left side of the political spectrum. So what could entice Republicans to join in a call for a constitutional amendment protecting the right to vote? So let me talk about three things. First, the most important thing, self-interest. That's what motivates political parties all the time. You know, Democrats in California, they were talking about lowering the voting age to 16. Do I think they're doing that because they think 16-year-olds are ready to vote? I think they're doing it because they think 16-year-olds will vote for Democrats. Right? So both parties tried to change the rules to make it easier for them. Well, what's happening now with the political parties? The political parties are changing. College-educated white voters moving more towards the Democratic Party. Poor voters, white voters and voters of color, moving more towards the Republican Party. The more you have poor voters moving to the Republican Party, the more the laws that make it harder for people to register and vote hurt the Republican Party. So I am hopeful that there's going to be a moment when it will be in the interest of both political parties to expand voting rights. So that's the first reason. There may be a period, and maybe by that point Democrats say, no, forget it. We don't want it anymore. In fact, this year, there's been a debate among Democrats because they've done a lot of efforts to, let's find those low propensity voters and let's register them to vote. Well, now we know those low propensity voters are more likely to vote for Trump, and so Democrats are not so interested in pushing higher voter registration for this group. But self-interest is one reason. Second reason is, if you really believe in election integrity, this is a pretty good deal. National voter ID, you don't see a lot of liberals talking about that. And here's a way to know that we're not going to have people double voting in 2 states. We're not going to have impersonation. All the things that people say they're worried about, if they're actually worried about them, this would eliminate a lot of those things. And the third reason, if you care about having elections not be stolen, the best protection is a popular vote. I mean, think about it. 150 million people voting. Very hard to swing an election when you've got that many people voting. We could change this with that. We don't have to federalize our elections. We don't have to turn it over to the federal government. States can still run elections, but we can do so in a way that both improves voter access and protects voter integrity. And so let me end just by saying that when we think about the Constitution, a lot of us, I think about it wrong. We think about the Constitution as a kind of sacred document, like the Bible, right? Like a religious text, like we can't mess with this. It's come down from God. And this is not how we should think about the Constitution. The Constitution was written so that it could be amended. And in fact, Justice Antonin Scalia, one of the leading conservative justices on the Supreme Court of the last generation, said it's too hard to amend our Constitution. It should be easier. It would make things better if we could actually update things in a reasonable way. And so we should not revere the Constitution as a dead document that can never be changed. But we should instead ask the question, how can this document be improved so that all Americans' lives are going to be better? Now, we might not all agree about how to do that, but having this kind of dialogue would make sense. If the last voting-related amendment that was passed and ratified was the 26th Amendment on age, 18 to 21-year-olds. That was 1971. A majority of Americans were not born in 1971. We've lost our muscle memory when it comes to amending the Constitution. So the Constitution, brilliant. It's brought us to, the heights of, at one point, of democracy around the world. We're no longer at those heights, and there's a lot of room for improvement. I end my book by saying that it's time for us to get to work. Democracy is not going to protect itself. And really, my message to you is, don't retreat into cynicism. Ask, how can we organize to make our country better and improve our democracy? Thank you very much.
Good. Thank you, Professor Hayson. I'm Sarah Farrow-Crowley, Director of Alumni Relations, and I have the pleasure of moderating tonight's Q&A. Before we get started, I'd like to remind everyone to please stay seated until the end of the program. You all have note cards and pencils on your chair. If you have a question, please write it on the card and raise it. We have ushers collecting them and bringing them to the stage. And I will now start with the first question that I have here. What types of innovative voting restrictions have states been implementing in recent years? In other words, what are the hot new trends in voter restrictions these days?
So the one I'm most worried about, well, let me back up and say that lots of states passed voter identification laws. I talked about that case out of Indiana. The evidence on whether lots of people are deterred by those voter identification laws is quite mixed. That is, people adapt. There's whole organizations, and if you want a great organization to look at, there's an organization called Vote Riders that actually goes around and helps people in states where they need to get IDs to actually get IDs. It's a great organization. That, I think some of the concern about voter ID laws is overblown. Here's one that I think is not overblown at all. In a few states, in order to register to vote, this is not to actually vote at the polling place, to be registered to vote, you have to provide documentary proof of citizenship. That is, you have to show a birth certificate or your naturalization papers, something that shows that you're a citizen. And we know that people do not, like if you're going into Costco and someone has a registration table, you're probably not going to have your birth certificate with you, right? So you're not going to be able to register to vote at that time if you're in a state that has one of these laws. There was a lawsuit against Kansas had put this in place. And in Kansas, in just the period of time when it was put in place until a court came and imposed a restriction, 30,000 people were denied the right to register to vote. And there was a trial over this law. And Chris Kobach, who then was the Secretary of State of Kansas, very much someone who claims there's a lot of voter fraud, he told the court in this trial that the amount of non-citizen voting that he could find was the tip of the iceberg. He found no cases. And the judge, who heard all the evidence, had a trial, Republican-appointed judge, said there is no iceberg, there's only an icicle. And it's made up of administrative error. And every person who registers to vote signs under penalty of perjury that they're a citizen. If you're a non-citizen, are you going to sign that thing knowingly and risk felony plus deportation? It just doesn't happen. And yet now in Arizona, they have imposed this rule. In Arizona today, if you go and try to register to vote, this is crazy because this is a combination of lawsuits and the state law and what the Supreme Court recently did. If you go and try and register to vote and you fill out a form that has been designed by the federal government, and you don't provide proof of citizenship, you're allowed to vote only in federal elections. If before August 29th, you filled out the state form and didn't provide documentary proof of citizenship, you'd be allowed to vote only in federal elections. After April 29th, you won't be registered at all. And only if you provide documentary proof of citizenship. So like it's going back to the Jim Crow, like pick up the wrong paper, you're disenfranchised. That is what's going on in Arizona right now. And I'm much more concerned. There are thousands of people who do not provide documentary proof of citizenship, not because they're not citizens, but because they don't have it handy. And when you put up hurdles, some voters, voting is not at the top of their list. Oh, there's another hurdle, I'm not going to bother. And so that is something that really is at the top of my list right now.
Thank you. This is a question from the audience. Why do you think the Constitution is set up in a way that lets the Electoral College pick the president instead of the populace vote?
So the history of the Electoral College is that the framers did not trust the people, right? That's why we couldn't vote for senators, right? Senators were chosen by state legislatures. It wasn't until the 17th Amendment in the early 20th century that we got popular election of senators. There was very little voting. You know, it's a republic, it's not a monarchy, but it's not really a democracy. And so we've expanded voting rights, but in a very odd way. And so it's not a surprise that the framers didn't want that, but why should we have to live under what the framers thought, right? You know, at the time of the Constitution, white men who owned property were basically the only ones who were allowed to vote. So that should be our standard for today? I mean, that just doesn't seem right. Again, if you think of it as a religious document, you know, and then we can't change anything, that's different than you think about it as these are our governing papers, and times have changed since 1789.
Thank you. If your ideal amendment was passed, how would the idea of equal weighted votes affect the Senate and Electoral College?
Right, so in the amendment, I carve those out. In the basic amendment, it says this doesn't apply to the Electoral College or to the Senate. So you'd have to have, and I have like a little red line so you can see how we could change it if we wanted to. But I really think, you know, I'm not under any illusion this is happening anytime soon. But if there is going to be a moment when there is more support broadly for voting rights, the Electoral College and the Senate would make it so hard because we have such a high hurdle to amend the Constitution to do anything. You know, I don't know if you've heard, there's talk about trying to do a constitutional convention. Have any of you heard about this? So Article 5 of the Constitution says there are two ways to amend the Constitution. One way, and it's the only way we've ever done it in this country, is that Congress passes by a two-thirds vote in each house an amendment, and then it gets ratified. The other is that there's a convention of people of the states. They propose amendments that are then to be voted on by the three-quarters of the states. There's almost no detail about how this convention is supposed to happen. And so people are really worried because there are a number of states that have called for this convention, and when enough states call for it, it's supposed to happen. I'm less worried because it's hard for me to think of any difficult issue today, abortion, immigration, you name it, that you could get three-quarters of state legislatures to agree on. I mean, it's hard to know what that would be. I would like to hope that voting rights would be up there, but I don't think that is true for today.
Thank you. In what circumstances do you believe a person should be disenfranchised?
A person should be disenfranchised. Well, I would phrase it a little differently. I would say, who should not be eligible to vote? So, one example, children, right? We don't allow 4-year-olds to vote. Now, we might disagree whether it should be 18 or 16, but like I think we would all agree 4-year-olds should not be allowed to vote. Why is that? Because we think they haven't formed enough of an opinion about the world to be able to make an informed choice. So there is some level. Non-residents, non-citizens. So if you look around the world at how other democracies do it, and I do a lot of that in the book, just about every other democracy says you have to be a citizen, you have to be a resident, you have to be an adult. You also have to have mental capacity. So if you've been declared incompetent, you're not allowed to vote. Beyond that, really the only category that remains is the felon category, and I've talked about how that's a difficult question. I certainly think that once people have finished their sentences, they should be allowed to vote. There are some people who think that, and the Canada's High Court, the equivalent of their Supreme Court, has said that in Canada, if you're incarcerated, even with a current felony, you have the right to vote. So there are different views on that. That one I think is a harder question.
Thank you. Would gerrymandering also be considered an attack on voting rights, especially in regards to equally weighted votes?
So let me first define gerrymandering. What is gerrymandering? So we're talking about the drawing of districts. So, you know, when you go vote, you vote for governor, that's not a district, right? Everyone in the state votes. But when you vote for your member of Congress, lines are drawn. That's the districting. When you vote for your members of your city council, your state legislature, it's done in districts. All of those, thanks to the Supreme Court's decisions, have to be done with equally weighted votes. Now, it's possible to draw districts with equal numbers of people in them, but that are still gerrymandered. So what's gerrymandering? The term comes from, there was the governor of Massachusetts. His name was Elbridge Gerry, and he drew districts to help his political party, and there was a cartoon in the newspaper around the time he was doing it about the shape of the district. It was Elbridge Gerry's salamander, because it looked like a salamander, and that's where we got gerrymander, which became gerrymander. And Elbridge Gerry's descendants wrote to Chief Justice Roberts at the Supreme Court and asked him, could you please say gerrymandering instead of gerrymandering during, and he didn't. He still said gerrymandering. So we say gerrymandering today, but it did change over time. You can draw districts that help one party hurt another while still complying with the one person, one vote rule. So I don't touch gerrymandering in this book. And I've been criticized for that. People think you really, to have a fair democracy, you've got to have those rules. But I was really trying to balance what is like the basic core and what is likely to create more disputes. And so I really focused on just the right to vote, even though I think you can make a case for trying to deal with gerrymandering as well.
Thank you. Do you think making Election Day a holiday would improve turnout? Some countries do this.
I think if we made Election Day a holiday, there would be mattress sales and people would take 4-day vacations. I'm not a big believer in making Election Day a holiday. What I would love to do is have early voting everywhere. Election period. Everyone should have at least 2 weeks to vote, whether it's by mail or in person or both. Because, you know, you give people off the day, it doesn't necessarily mean they're going to use it for voting. But if you give people a long enough period, then they can work what's convenient. You know, I talk to a lot of election administrators, and they want to make things easy for voters. But they have to do it in a way that complies with state law, and that's fair. So during the pandemic, I told you how Texas didn't have a lot of voting by mail, but they had in-person voting, had early in-person voting. Well, in Harris County, which is where Houston is, they opened 24-hour drive-through voting because people didn't want to get out of their cars. The pandemic, you know, you just roll down your window, cast your ballot, hand the thing back. Seemed like a great innovation to me, and then the Texas court said that that violated state law, and the Texas legislature passed a new law saying you can't do that. So, you know, we still have these, you know, kinds of fights over voter convenience. Now, I certainly understand limits on voting that are based on real concerns about fraud. Let me give you one counterexample, since I've been just talking about things where fraud's not a concern. Let me talk about where I think fraud is a concern. So people vote by mail, and those ballots are out of the control of election officials, right? So anytime ballots are not in the control of election officials, something bad could happen. Doesn't mean it's going to, but there's the greater potential compared to if ballots were always in the presence of poll workers, right? So in some states, there are limits as to how many ballots you might be able to collect from your neighbors. So like in Colorado, you can collect up to 15 ballots. In some states, you can't collect them at all unless it's a relative. In California, where I live, unlimited collection of ballots. This is sometimes referred to pejoratively as ballot harvesting. Well, we know that there was a scandal in North Carolina in 2018 where a Republican candidate's operatives were collecting mail-in ballots. They were destroying some ballots, they were changing some ballots, they were telling people how to vote. So I think we should have reasonable limits on the collection of these ballots, not because there's a lot of fraud, but there's enough of a reason for it, and there can be a balance. And there can be exceptions. For example, I talked about voting on reservations where people don't have easy access to the mail. Well, either the state has to put in drop boxes so people have access, or the state has to allow some form of collection, or the state has to do the collection themselves. But we should make voting convenient and secure.
Thank you. What would be the first step towards starting a national movement to expand the rights of voting?
Someone should write a book. You know, I'm not a political activist. That's really not my skill set. But I'm hoping people will pick up some of these ideas and they will start. There are lots of different voting rights groups. But lots of times they are focused on like the next election. Like what's going to happen in 3 weeks? What's happening in Georgia right now with the changing the certification rule, right? They can't think big. So I'm hoping, trying to get a few members of Congress interested in proposing a constitutional amendment, some legislation, get people talking. One thing that's happening in a number of states, which has been I think a great improvement, is states have started passing state voting rights acts. So we have that in California and Washington State. Michigan just passed it. The problem is that these voting rights acts, state voting rights acts, are not being passed in the states that need it the most. There is no voting rights act in Texas or Louisiana.
Thank you. What should a revised Senate look like?
If we got rid of the Senate, what would we replace it with? Well, we could replace it with the equivalent of another house. That is a body where the amount of representation each state has is based upon the population of each of those states. Now, you may say then there's no point in having two houses, but let me remind you that every state, including New Jersey, that has an assembly and a Senate, it's the same thing. They're done based on equal population. And maybe you have a smaller number. Some have proposed that, you know, when we started out in the House, members of the House represented just, 10,000 people, 100,000 people. Now it's much larger. Maybe we need to make the House much bigger and keep the size of the Senate relatively small compared to the House.
What questions should minorities be asking to ensure their fair right to vote?
Well, I think everybody should be asking the question, why, when facing a voting restriction, why is the state making the right to vote harder? What can we do to ensure that people have equal access? And the most important thing that I think could be done to protect minority voting rights today, we're not going to get this amendment passed anytime soon, is that Congress should pass the John Lewis Voting Rights Amendments Act. It's a part of, it's a statute that would renew parts of the Voting Rights Act that the Supreme Court struck down in its 2013 Shelby County case, and would strengthen voting rights not just for minority voters, but for all Americans. That's a piece of legislation. When the Voting Rights Act passed in 1965, and when it was renewed in 1970, 1975, and 1982, and even in 2006, large bipartisan majorities, Democrats and Republicans, supported it. Now we're so polarized, I would like us to come back to a point where both Democrats and Republicans believe in equal voting rights for all Americans.
Thank you. We have time for 2 more questions. Could President Biden enact election guardrails through executive order before he leaves office?
I hope not. I don't think the president should be anywhere near running the election. And you might be worried about Biden. I was worried about Trump. The president has no role. And in fact, in his criminal trial, which may or may not ever happen, in Washington, D.C., the one for election interference, not the other ones, he is saying, well, this was my role as president, to make sure the election was done well. The president should have nothing to do with running the election. The last person who should be figuring out how we're running the election for president is the president. So as much as President Biden can do things, and he has done things to expand voter registration. There's federal laws that promote voter registration, and there are executive orders that promote it. But when it comes to actually running the election, that's not the role of the president. But I should say, and this is a really important thing, maybe a positive note to end on, or I guess we have one more question, but almost end on, is that in December of 2022, Congress passed a law called the Electoral Count Reform Act that probably very few of you ever heard of, but it's a law that changed the rules for how Congress counts the Electoral College votes to make it harder to steal elections. To say, for example, the vice president can't just throw out votes that she doesn't like. Part of the reason I think it passed is, who's the vice president now? It's a Democrat. maybe Republicans were willing to get on board and say, okay, we're not going to let the vice president throw out votes the way Trump was saying Pence should throw out votes. They passed a law on a bipartisan basis that improved our democracy. So that's a good thing. So it is possible. It takes a crisis, but at least it shows that some progress is possible.
Thank you. Okay, so for our last question, in the absence of a voting rights amendment, do you foresee a path to strengthening voting rights that would not inevitably be struck down by the Supreme Court?
So I do think that there's a lot that can be done that would be constitutional. I don't know exactly what the Supreme Court will do, but I had it on this slide here. Constitutional anti-hardball. It's an academic theory, it's not mine, but basically the idea is if the Supreme Court is going to block voting rights, then maybe you need to think about changing the Supreme Court. That when we talk about voting, maybe you need to get rid of the filibuster to protect voting rights. That maybe we need to change rules that protect the minority in the Senate and use more majoritarianism in order to promote more democracy. That's a very controversial idea, not using the normal channels, but the idea is use the abnormal channels, like getting rid of the filibuster, in order to promote democracy in the long run. Exactly where that shakes out, I'm not sure, but as I said, the very first thing would be passage of the John Lewis Voting Rights Amendments Act, and would the Supreme Court strike part of it down? It might, but then that should spur more of a political movement to further voting rights in this country.
I'd like to thank everyone for their great questions this evening. Professor Hassan, thank you. We appreciate your sharing your time and your expertise with us. Thank you for celebrating Constitution Day with us at Stockton University. I'd like to now introduce Dr. Tina Zappilli, Faculty Director of the Hughes Center for Public Policy, who will deliver closing remarks.
On behalf of the Hughes Center for Public Policy, I'd like to express my gratitude for Rick's time at Stockton University today and for all of you being here tonight. We especially appreciate seeing our community, Hughes Center Advisory Board members, and other esteemed guests get an opportunity to welcome our speaker and interact with our students, faculty, and staff. You can find a recording of this conversation posted to the university's YouTube channel in the coming weeks. We appreciate your continued support of the Hughes Center events like this that foster civic engagement and provide a forum to discuss policy issues and the politics behind those issues. I will close the evening with the following statement from our Constitution Day Committee. Each fall, Constitution Day provides us with the opportunity to engage with our founding document and how its principles resonate today. This includes confronting where the Constitution may fall short. Among the many constitutional issues we've tackled since its signing in 1787, 45 minutes away in Philadelphia, and we continue to grapple with today, many people do not realize that we lack an affirmative right to vote in our Constitution. We invite you to read Rick's book, A Real Right to Vote, and copies are available at our bookstore and tonight at the Board of Trustees room. You can see me after for directions. Thank you again, Rick, for helping us commemorate Constitution Day here at Stockton University, and thank you all for coming tonight.